A joint tenancy with right of survivorship, known simply as a joint tenancy, can only be created if there is specific language that indicates that a joint tenancy has been created. In Weems versus Frost National Bank of San Antonio, we'll see whether the word jointly was sufficient to create a joint tenancy. In 1933, Zuleika Weems Felder created a will that devised one half of her one-third interest in a gas and sulfur royalty to her cousins, including M.A., Z.E., and S.S. Weems, as well as A.I. Craig and the children of her deceased cousin, M.L. Weems. The will stated that the one half of Felder's one-third interest was to be held by the cousins, quote, jointly, unquote. After Felder created her will, M.A. Weems, Z.E. Weems, and A.I. Craig all predeceased Felder. In March of 1953, Felder died. S.S. Weems filed a lawsuit against Frost National Bank of San Antonio, the executor of Felder's will, claiming that Felder's will devised a joint tenancy to S.S. and the other cousins. Because all the other named cousins were dead, S.S. claimed that he was the sole owner of the Felder's property interest. If a tenant dies in a joint tenancy with right of survivorship, the deceased's share in the property will automatically transfer to any surviving co-tenants. In contrast, when a person in a tenancy in common dies, his or her share won't transfer to surviving co-tenants, and that person's share will remain in his or her estate. The trial court held that Felder's will didn't contain any words of survivorship, so the property interest was conveyed to the cousins as tenants in common. S.S. appealed to the Texas Court of Appeals.